Hello class. Today we are going to start another topic, that is patents. Before discussing this topic, let us revise what we have studied yesterday. In the first lecture we studied about what is intellectual property rights, what is the importance of intellectual property rights, what are the various types of intellectual property rights. So today we are going to discuss. As we know that there are different types of intellectual property rights such as patents, copyright, trademark, then we have trade secrets, geographical indication, etc. So today we are going to discuss the first and very important intellectual property rights, that is patents. You must all have heard about patents. Uh, as a layman, as a general public, you must have come across this word that this company has this much number of patents, this particular work is being patented. So what exactly patent is? For a layman, in general, patent means nothing but the term patent is derived from the word patente, which means to open. Like, as we know that patent is granted for any kind of invention. Invention means something which is done for the first time, which is not any new thing which is not done earlier by any other person. So it is something which is novel, something which is new, which is very beneficial for the society, which can be used in the industries. So this word patent is something which is the result of the hard work of the inventor, hard work of the creator. Like for example, if we take example of Thomas Alva Edison, as you all know that electric bulb was first time invented by uh, Thomas Edison, and it was not done over a night. It took so many times, so many nights he has spent so many days and failed so many times. After a long experiment, he was able to invent the bulb which we are using in different ways in today's life. So, this particular invention is the hard work of some person. So, this should be the exclusive right. The person must enjoy the exclusive right over that particular work, and this is how, by patenting a particular work, you get the legal protection of your work. Means it prevents others from using it, from manufacturing it, from selling it, from licensing it, assigning it, so many things. It prohibits others. So it becomes the monopoly of the patent holder, or rather you can say the inventor or the creator who has invented that particular thing, maybe in the form of a process or in the form of a product. So friends, that is the reason this patent is granted, and one must seek patent protection for any kind of invention. Patent is also granted for innovation. Now there is a slight difference in invention and innovation. Invention means anything which is done for the first time. If someone has invented any product for the first time which was not there earlier, that becomes a subject matter of the patent. Similarly, uh, like for example, if we can take example of various things, like for the first time aeroplane was being invented. Yesterday we discussed about so many examples, like Jaipur food, and for the first time, like if we take example of uh, four-wheeler car. Okay, so initially we used to have a very bulky car. Now we are having car with so many features. We are having, earlier we used to use car which was run by diesel. Then we had different type of car, like in the uh, previous and currently also we are using car with the help of petrol, and now we are having electric vehicles. So this is all invention. Invention is whatever is done for the first time, means it is not being done earlier by anybody. Now suppose if anybody is making any kind of modification, any kind of changes in the existing product, which might enhance the efficiency, which might enhance the design, or which may save the time, or which can give a better look. So if, or it can be, it can also, if we take example of a process, it can also be if somebody is minimizing the process, if it is a 5-step process, and if the process is reduced to 2 steps, 3 steps, then this also can be called as a innovation. So the uh, patent is granted only for invention and innovation. So the definition which is given in the Patent Act is as follows: a patent is a set of exclusive rights granted by Government of India to an inventor for a limited period of time, excluding others from making, using, selling, importing the patented product or process, producing that product for these purposes. So here the definition itself is very explanatory. It is who grants the patent? The patent is granted by Government of India. To whom it is granted? It is granted to the inventor, the person who invents the particular product or process or any other design. And this particular patent or this particular grant is given for a limited period of time. Now, if anybody has got a patent, it does not mean that it is for unlimited time. It has some specific time. In case of patents, it is generally for 20 years period. After 20 years, the patent is no more a patent and it comes into public domain, means anybody can use that particular invention. The person who is the inventor or the person who is granted the patent is known as patentee. Now, very interesting, why the patent is granted, what are the objectives of the patent. So here we will discuss one by one. So class, first point is to provide protection of creativity to the creators. As I have said that creating something is not a joke. It takes labor, it takes time, it takes lot of efforts. People fail so many times for inventing a particular thing. So it is the work which has to be protected, which has to be, the creator must get some protection, some legal protection. So this provides, the patent provides legal protection to the inventor, by which the inventor can legally protect the work, and it prevents others from the benefits which can be enjoyed only and only by the patent holder. Then it promotes the creativity of new creators. Yes, very true. The creators must get something. Why a person will create? Why the person will innovate? Why the person will go for invention? There must be some motivation. So this particular patent, it promotes the creativity because with the help of this getting the patent, the inventor is motivated because the patent holder gets so many benefits. Okay, so that is why It also promotes research and development in any country, which is very good for any economic developing nation. So another thing is, it is very useful to accelerate the technological and industrial development of the country. Yes, the industrial and technical development of any country will only accelerate only if there is sufficient scope for research and development, if there is innovation. Otherwise the country will lag behind. So this is one of the very important aspect, that there has to be promotion of technological advancements, industrial advancement for the development of the nation, and specifically for the developing and the underdeveloped nations. To provide exclusive right to the invention and affords protection against unauthorized use of invention by the third parties. Yes, this we have already discussed, that it provides exclusive right to the owner. It provides monopoly to the patent holder, means the rights which are enjoyed cannot be violated by others. It gives legal right to the patent holder. So the patent holder can enjoy the monopoly rights over the particular invention. It helps in understand the meaning of specification. This specification is very important. When the particular invention is done, it is followed by some specifications, what is different, how it is different by the other inventions. All these are explained with the help of specification, which is very important for any patent holder for the grant of the patent. It encourages inventions by promoting their production and utilization. So it encourages, it motivates more and more inventions in a country, because when a person goes for patent, then people are motivated because they get extra monetary benefits, they get recognition for a particular invention by protection of their intellectual property right by way of patent. Now friends, this is very important to understand that what kind of inventions are patentable and what kind of inventions are not patentable. Now, patent invention does not mean that anything you are doing some modification in the existing product, or you are doing it has to be patented. So such kind of inventions are not considered as inventions, and it will be rejected by the patent office. The next is a method of agriculture and horticulture. So if you have invented any new method of doing agriculture, any agricultural method like by which you can enhance the production, or you enhance the quality of the seed, or any other thing by which you can reduce the age of fruits, like the plants. Suppose if a plant gives fruits after 5 years, then somebody has invented that it can give fruit after just 1 year. Then such kind of inventions related to the agriculture, and in case of horticulture, such inventions can also not be eligible for the grant of patent. Next is any process for the medicinal, surgical, curative, prophylactic or other treatment of human beings and animals and plants to render them free of disease. So any medicinal process, surgical process or curative process for the treatment of human beings and animals and plants that render them free of diseases. So such aspects are also not a subject matter of the patent. These are not patentable and not considered as invention for the purpose of patent. Then scientific discoveries. So this is as I have told you earlier that the patent is granted only for inventions, and it does not covers the discoveries. There is a difference between discoveries and inventions. What is discovery? Discovery means anything which exists but it is not known, and if you explore that, if you bring that particular knowledge, that particular aspect in the knowledge of the public, that is a discovery, and that discovery is not a subject matter of patenting. Mere discoveries of new forms of known substances, whatever substances are available, you are just identifying those things, and you are publicizing in the society, so that is also not a subject matter of the patent. So any literary work, artistic work, musical work, dramatic work including cinematographic film and recording work, all these various types of work are also not patentable. They are not considered as invention, and these various types of works can be protected through another law that is known as the copyright law. Then plants and animals in whole or part thereof other than microorganism. So any plant, any animal, that can also not be patented because it is created by natural law, it is creation of God. So that is also not a subject matter of patent. Next point is inventions being frivolous or contrary to public order, morality, public health and the environment. So any invention which the public does not appreciate, if it is against the public policy, if it is against the morality of the public, if it is harmful to the environment, then such inventions are also not patentable. Next is topography of integrated circuits. Topography of integrated circuits are also not patentable, as in the earlier lectures we have discussed that there is a separate law, that is Semiconductor Integrated Circuit Layout Design Act, and these are protected under that particular law, so it is not protected under the patents. And traditional knowledge. Traditional knowledge is nothing but it's a body of knowledge which we have got through our ancestors, which is passed from generation to generation, which is not written in the books, it is just passed by word of mouth, and this knowledge is also protected by a separate instrument by different authorities, so that is also not a subject matter of patent. So all these aspects are under the Indian Patent Act, they cannot be patented. So till now we have discussed what is patent, what are the objectives of patent, and who can obtain patent, and what are the inventions as per the Indian Patent Act which can not be patented. So friends, now we will see what can be protected under the Patent Act. So here we will discuss the patentable inventions. What are those inventions that can be protected through grant of patent? First and foremost important aspect, important element, that is the novelty. Any invention which has some newness, which is novel, which is new, only that invention is eligible for patent. This is the first and foremost important element, first and foremost important criteria for grant of a patent. So the matter disclosed in specification is not published in India or elsewhere before the date of filing of the patent application in India. So any such thing which is not published anywhere, any such invention which is not recorded anywhere, so which is done for the first time, then only that particular invention can be patented. Another important element for getting patent is industrial application. Any invention which can be applied by the industries, which can be used for commercial purpose, which can be used in the industries, which is very useful to the society, only those inventions can be granted patent. So invention should possess utility so that it can be made or used in the industry. So as you all know that whatever is made in the industry or whatever industry uses, it is only and only if it is useful to the society, if there is a demand for that particular product. So only those things are considered for industrial application. Next is inventive step. There has to be an inventive step. This is the third most important criteria for the grant of patent. So invention is not clear to a person skilled in light of the prior publication knowledge document. So inventive step simply means that whatever invention is done, it must be based on certain body of knowledge, certain experiments, certain procedure. It is not simply doing anything and just applying for the patent and waiting that the patent will be granted. It's not like that. So whatever invention is done, that must be based on some rules, based on some scientific principles, some laws, some experiments. Then only it is eligible for the grant of patent. Then it must be novel, new, and basically the patent is granted for the product and the process. Product patent means if somebody is making any new product and that particular product is applied for patent, then that is a product patent. Process patent means if any, like for example in pharmaceutical industry, the process, so many processes followed for manufacturing of medicines, for manufacturing of syrups and health drinks and so many things. So there they are following some process. So this process can also be protected under the patent, like products. So here up till here I think it is clear that what can be patentable and what cannot be patentable. So I would like to repeat again that these are the criteria which are important for the grant of patent. The first thing is novelty. The invention must be new, novel. Then industrially application. There has to be inventive step. Patent is for new product and process. And one most important thing is the public must accept that there has to be, the particular invention must have a public utility. It must be useful to the society. Anything which is not useful to the society, that is not considered for the patent. So whatever is useful to the society, if it is beneficial to the society, beneficial to the public, beneficial to the environment, beneficial to each and every organism on the earth, if it does not harm anybody, any organism, environment, then that thing is considered for the grant of patent. So friends, now we will discuss the various types of patents as per the Indian Patent Act. So first is ordinary patent. An ordinary patent is a patent which is applied within the territorial boundaries of the nation. That is called as ordinary patents. So there is provisional patent, convention patents. PCT means Patent Convention Treaty. We will discuss what is Patent Cooperation Treaty in the upcoming lectures. Patent Cooperation Treaty National Phase Patent Application, Patent Cooperation Treaty International Application, Patent of Addition and Divisional Patent. Now we will discuss one by one the various kinds of patents. Now this classification is done on the basis of application. First, ordinary patent application. So, what is ordinary patent application? As I told you, it is used to file a patent application directly in India. If you are applying for patent within the country, within India, then and you want to seek protection only in India itself, then that particular patent is known as ordinary patent. Second type of patent is PCT, that is Patent Cooperation Treaty, National Phase Patent Application. Now this particular patent is basically used to first enter into the nation and then through that, after entry into the nation through Patent Cooperation Treaty, then you can enter in the other countries or in multiple countries for protection. So that is known as PCT, National Phase Patent Application. So first here you have to enter into the Indian PCT treaty, and then after filing protection in Indian PCT, then you can further go ahead for multiple countries for the protection of your patent. Then there is next one is the Patent Cooperation Treaty, International Patent Application. Now this is used to file a single patent application for patent registration in multiple countries. So what happens, friends, when, as I told you, that the patent is based on the territorial, it has a territorial jurisdiction. Like if you are filing a patent in India, then you will get protection only in that particular country. And earlier what used to be done is, if you want to get protection is in multiple nations, then you have to file patent in multiple countries. But now this has been improved, this has been eliminated, and now the new method is by filing an international PCT patent application, you can simply file in one nation and you will get the protection in multiple countries who are the member of the PCT International Patent. Another next is the Convention Patent Application. So this particular Convention Application patent is used to claim priority based on earlier application filed in a convention country, and it allows to secure the priority date for their invention. So here, as you can see, that it is used to claim priority based on earlier application filed in a convention country. What is a convention country? Friends, we will discuss in the upcoming lecture. Like there are various conventions. Earlier there was no particular codified law, there was no laws in different countries. So earlier, like there is a Paris Convention. Paris Convention took place in Paris, so it is known as Paris Convention. And it was for the protection of the inventions. So this convention took place in the year 1883. Similarly, there is a convention that is known as Berne Convention. Berne Convention is the convention which is for the protection of the copyrighted work related to artistic, literary and musical work, etc. So if any country wants to seek protection through any convention, if it is a member of that particular convention, like India is a member of Paris Convention, okay, we are also a member of Berne Convention. So if a particular country wants to seek protection in a particular convention, then they can go for this particular patent application. Now one important thing you have seen here, that is secure the priority date for the invention. Now as far as the patent is concerned, the priority date is very important. What is priority date? Let us understand this particular aspect. Priority date is the date on which the application is filed. Now this is very important. Specifically, when suppose if you have done any invention and similar invention is done by some other person also, by some other party also. But the one who approaches first for the registration of the patent, for the grant of the patent, then that person will get the protection. The other person will be denied because you have approached first. So that is the priority date. So as soon as any invention is done, one must get it, at least apply for the patent, and that becomes a priority date. Because if somebody else work in the similar area, similar invention is done, then it will prevent that person from getting the patent. So this is very important. The next is the divisional patent application. Divisional patent application means, like for example, if a person applies for a patent and that particular patent can be claimed claimed with multiple inventions. So instead of one patent, you can apply for 2-3 patents depending upon the inventions. Like there may be small inventions, and you can separately claim for multiple inventions, for multiple patents. That is called as divisional patent. Here you can, instead of filing a single patent, you can break up the entire inventions into 2-3 parts and separately apply for the patent. That is called as divisional patent. You can do it by yourself, or the patent office may ask you to go for the divisional patent. The next is patent of addition application. So what is patent of addition? Patent of addition means, suppose if any company or any inventor is making some modification in the existing product. So specifically for that modification, for that upgradation, you can seek protection. So for that particular aspect, for that particular part which is being introduced, which is being modified, for that particular aspect you can seek patent. Like for example, if we take example of mobile phone, like there are so many features, and if you add 2-3 more features into that, then you can get patent protection for that particular thing, upgradation which you have added or which you have done modification. Only that aspect is being covered, which is known as the additional application, patent of addition. Here you are not making any major change in the existing product, but you are introducing some new aspect, or you are making some small modification in the existing invention, which is known as patent of addition. Now, what are the responsibilities of the patentee? Now see, the Patent Act, the patent gives certain rights to the, certain exclusive rights to the patent holder, but at the same time it also fixes some responsibilities on the patentee. First thing, that to encourage and secure working of invention to fullest extent without undue delay, means once you have applied for the patent, once your invention is complete, then you must immediately execute it for the benefit of the society. You must not hold that I will release my invention, I will introduce my invention to the world after 4 or 5 years. No, this is wrong. So whatever invention is done, you must release it, you must introduce it in the public as early as possible. You must disclose your invention in the patent office as early as possible, and you should also introduce your innovation which can be useful to the society, to the masses, to the world. The next is not to use monopoly to unfairly prejudice, or you can say interest of the public. So whatever invention is done, that should not be, the inventor must not aim at his own personal benefit. He must always keep the interest of the society on the front. So first it should benefit the society, and it will also, secondly, it will also benefit the inventor. So the interest of the society must be given priority for the particular invention by the patentee. Means it should not, the patentee should not make negative use or should not aim only for the personal goals or for making personal profits. Okay, so the main objective of any patentee is to give the benefit. The benefit must reach to the society at large. Next is failure to discharge duties reasonably would lead to revocation of patent. If the patent office also has the right to revoke the patent if the patentee, if the inventor is not discharging the duties properly, so the patentee or the patent holder must discharge the duties properly. That is what we have discussed earlier. It must not involve in malpractices, must not involve in unfair practices. It must always aim for the benefit of the society. Whatever it does, he or she does for the interest of the society at large. To furnish periodical statements, the controller as to extent to which invention has been worked. So the patent office also asks for the periodical review, what has been done till now, what is the status of the patent in the society, whether the patent, whether the invention is commercialized or not, whether the public is happy with the particular invention or not, what are the reviews. So many things are being asked by the patent office. So all these things has to be submitted periodically by the patentee to the patent office, or you can say patent office means it is controlled by the Controller General of Patent, Design and Trademark. The failure to provide statement to controller is a punishable offence. So it is the duty of the patentee to provide the periodical statement to the controller from time to time as and when required. Now, what is the term for patent? What is the duration of patent? Friends, in general, the tenure of patent is for 20 years. But it varies from invention to invention. Like in some of the invention it is for 14 years, for some of the invention it is for 7 years, and it also varies from country to country. But in India it is for 20 years. Like here we can see if it is a patent of addition, we have discussed different types of patents. So if it is a patent of addition, then the term equal to that of the patent for the main invention. So whatever term is there for the main invention, the patent of addition, if some modification is done, then that particular modification, that particular aspect will also get patent for similar time, similar to the main patent. Then substances which are capable of being used as a food or medicine or drug. So in case of food products, in case of medicines, drugs, so it is 5 years from the date of sealing or 7 years from the date of patent. So there is a separate rule for the purpose of food, medicine and drug, and for any other invention, any process, it is 14 years from the date of the patent. And in general, it is, if it is a product patent, so in general it is for the period of 20 years. So these are the rights of the patentee. So first is the right to grant the license. The patentee has the right to grant license for use of a particular invention, for use of a particular patent at a price which can be fixed by the patentee. Then right to surrender. If the patentee feels that the patentee does not want to continue with a particular invention, then it can go for surrendering the particular patent. Then right to sue the infringement. If somebody is violating the rights, as we have discussed that it is to prevent others from using the rights, it prevents others from using the particular invention. Then if somebody is violating these rights of the patentee, then the patentee has a right to sue or file a case against the particular infringer or the particular violator. Then he has the right to exploit the patent. The patentee has the full right to exploit the patent to the full extent. So the patent holder gets the right to distribute, to sell, to make as many as products, as number of products as wants to, as it feels, as it wishes to manufacture. He can license the particular invention. So all these things are granted by the controller to the patentee. Now, what are the documents, what are the important information which is required for the grant of patent? If you wish to protect your invention and get legal protection for your invention, then you have to approach to the Controller General of Patent, Design and Trademark for the grant of the patent. So what are the things which are required, or what information has to be disclosed to the patent office? First thing is, which information does a patent document provide? What kind of information you have to see? What kind of information is asked by the patent office? What is the technology field of the invention? What technology, what is new, what technology is being used for the purpose of invention? Which technical problem is solved and how? What is the problem for which the particular solution is provided with the help of technology, with the help of process, with the help of method. So what is being provided? That has to be mentioned very clearly. What is the prior art? What has been done? Actually, what is the invention? What is new? What is different? What you have done which is not done by earlier inventors? So you have to mention all these things. Who is the inventor? The name of the person who has invented that particular thing. So the name is also very important. When and where the application for patent was filed. So if application was filed, you have to mention that when did you file the application and where did you file the application. Like we have discussed various types of applications, various types of patent applications. You have to mention that also, and name and address of the inventor. So these are the documents which has to be disclosed for seeking the patent. So we will stop here today and we will go for the other aspects of patent such as the registration process, fees, and other legal aspects in the upcoming lecture. Thank you very much, class.